Yes, Judge. Your Honor, this may be a little bit more lengthy than the court might think. I am making a judgment of acquittal on behalf of Zvante Sampson as it relates to all of the counts he's charged with in the information: premeditated first-degree murder in count 1, attempted premeditated first-degree murder in count 2 and 3, conspiracy to commit first-degree murder in count 4, and shooting into a vehicle in count 5. In that, I believe that the state has failed to present a prima facie case as to those counts in relation to Zvante Sampson. 782.041A addresses premeditation as it relates to murder and attempted murder in the first degree. Premeditation is killing after consciously deciding to do so. That decision must be present in the mind at the time of the killing when we're talking about premeditation as it relates to first-degree murder. The law does not obviously fix that exact period of time that must pass between the formation of that intent and the killing. The period of time must be long enough to allow reflection, and it must be formed before the killing. This case is not charged as a felony murder, as the court knows, and Zvante Sampson is not alleged to have possessed or discharged a firearm. He did not actually commit a murder or an attempted murder, and therefore the only way that he can be convicted is if there is sufficient proof, and at this stage of the game, prima facie proof, that he acted as a principal. This case, I would suggest to the court, from a prima facie standpoint, rises and falls with a series of videos as it relates to sufficient prima facie finding for this case to get to a jury as to Zvante Sampson. I know that the court has not had the best benefit of the ability to see the videos that are introduced and in evidence, simply because of your trajectory, if you would. I believe that if you look at those videos individually and or collectively, it would suggest that as to Zvante Sampson, a prima facie finding has not been carried by the state. When we talk about the witnesses, Detective Celaya provides no testimony as to Zvante Sampson other than identifying him and his car, noting communications with various individuals. Some are co-defendants, some are his brother. They occur earlier in the day on the 22nd of August. They occur on 2 occasions after the murder during the same night, and certainly in the days that follow. All without any of the slightest idea what the substance of any of those conversations are. And I think that's critically important when the court decides whether or not the state has met their burden at this stage of the proceedings. He opines that he sees muzzle flashes from the vehicle, but has no evidence to provide to the jury that Zvante Sampson had one lick of knowledge as to what was going to happen. Again, Zvante Sampson doesn't discharge or possess a firearm, and therefore principles is the critical theory in this case. There is evidence that Detective Celaya provided that Zvante Sampson's phone was in the general area of the scene of the crime, but there's no speculation or nothing other than speculation as to why he was actually there at that moment in time. Willie Brown identifies no one. He does testify that Suni Bell was screaming when he got out of the car, that one vehicle had fired shots at that time prior to him running away. Mary Harrison nor Willie Brown can provide an identification of Mr. Sampson actually committing a crime. Again, I won't keep saying the word principles, but I think certainly that's the critical finding here. We know that he fired no gun. Mary Harrison testified that after the first set of shots, she started to drive, and that when they stopped, she heard Suni Bell say, "Mommy, Mommy," and at that stage of the game, it gave her the opportunity to get into the driver's seat and attempt to drive. So what do the videos show that rises to the level of a prima facie case as it relates to Zvante Sampson? No video shows when and if Zvante Sampson sees any gun possessed by anyone.
Other than the video of them getting in the car with the guns?
Not in Vehicle 1.
Vehicle 1?
No, sir.
So the shooting that was going on in the car that he was alleged to be driving, he wouldn't have known there were guns?
No, Judge, I don't think the video nor any testimony before the court would indicate that he knew that anyone in his vehicle was carrying a gun.
There were rifle and pistol rounds all up and down Hillsborough Avenue.
Judge,
at what point doesn't he know somebody in his car is hanging out of the window shooting at someone else?
The hypothesis of innocence is certainly that when the gunshots, when the gun,
understand the state's position.
Well, Judge, when the state can't tell us when he knows. There's no evidence.
All right, let's bring in National Trial Attorney Jury Consultant Wendy Patrick. Wendy, thank you so much for joining. I understand where this defense attorney is going and keeps focusing on the fact that he wasn't charged with possessing a gun or discharging a firearm, yet they're saying he's a principal in the murder. Your thoughts?
You know, this is where it's challenging to be a defense attorney when even the judge interjects that, wait a minute, circumstantially, he's done. When you look at all these facts and circumstances that indicate that he had to have known. But, you know, as a defense attorney, you have to really split hairs and be very articulate about the standard of proof and whether there's any direct evidence, circumstantial evidence. And that's what this attorney is doing. You know, he's going through his notepad. He's ticking off everything he needs to do. He's making a record. You know, on appeal, this is the kind of record he needs to make, even if he's maybe doing it with the full knowledge that he's not going to win this motion. You have to make these motions. I'll tell you also, this is complicated by the number of defendants you see here, because remember that each attorney is doing everything they can to distance their client from the actions of the others. You know, many of these cases we have what we call a heavy. You have somebody that seems to be the ringleader. But if you have 5 defendants, sometimes it gets tricky to try to figure out if things are moving fast and bullets are flying and different guns are used, who that necessarily is when things move the way they do in a case like this. So this motion has to be made. It's interesting to see the interaction between the defense and the judge, because you can imagine that's what the closing argument is going to look like as well.
Yeah, fair enough. And it sounded a lot like his opening statement as well. So he's going to make this argument yet again. I think one thing that I think you can say, or you let me know, works in favor of the defense is the idea that there were a number of guns, I believe 4 or 5 guns used. They could really only match casings to one gun. They were able to say that there was a rifle at the scene and there were something that was looked like a rifle casing, but didn't connect it directly because they don't have the rifle. So at the end of the day, how helpful is that to the defense? Because again, remember, they are arguing that they were shot at. And again, I don't know how that holds up. But anyway, with the fact that casings were found that you can't connect to any guns connected to them except for one, seems like something they could argue and maybe win a juror or two.
You know, Michael, actually, I think you might be a good juror on a case like this, because you've just identified some of the difficulties, even for the defense on a case that's just a mess in terms of who used what type of gun. But we live in a day and age where forensics tell a story that even recipient witnesses cannot, because they may not have seen, they maybe have been ducking for cover, not watching in the right place, lots of action, lots of confusion, it's dark, there are lots of people moving around. But bullets and guns tell a different story if that tale is put together in the sense that a jury understands the timeline. Yes, it is complicated when there are 5 people at the scene, but not so complicated that investigators can't put it together. So that is one of the things that ends up being the most reasonable explanation of the evidence. And that's what these defense attorneys are going to be challenged to try to rebut.
Yeah, making some interesting arguments.
Yes.
And we're going to continue with those arguments when we come back. We're going to take a quick break, so keep it here on Court TV.